I'm Jill Alpes. I'm a senior research associate at the Paris Institute CESMA and at the Institute for Migration Studies at the Lebanese American University. I am specialized in combining anthropology and law for questions of migration. As a legal anthropologist, I have carried out long-term fieldwork both on the African continent and in the Middle East, particularly Cameroon and Lebanon. I also worked as a research consultant for human rights organizations at external EU borders, including for Amnesty. And at the moment, I'm co-leading 2 new research projects for the next 5 years where we investigate the temporal and spatial dimensions of the non-refoulement norm, specifically for the case of Syrians in Lebanon, Turkey, and also Europe. And we want to investigate and show the life trajectories of people after removal, which often include returns to actual prior host countries. And with that, we also want to show how mobility control functions as state making and the broader societal implications of mobility control and removal infrastructures. At the European Court of Human Rights, the judges assume that member states of the Council of Europe, have acted in good faith with regards to their obligations, their convention obligations. So this is the good faith principle. This means, consequently, that when a pushback survivor makes a claim about a rights violation in front of the court, that the burden of proof, so it's on them to make a case that his or her or their rights have been violated. In addition, there's another principle that's important for the evidentiary regime at the European Court of Rights, and this is something that comes from our research. So it's not anything that is spelled out explicitly black on white, namely that judges tend to give greater weight to state evidence than to non-state evidence. So all of these principles, the good faith principle, the burden of proof, the way that different types of evidence gets weighed, this is always the case for all court judgments that come from Strasbourg. Now, what is specific for pushbacks is that, first of all, there's more factual disagreement because the cases generally have not been in a domestic instance beforehand. So it's also harder for the judges because they don't have a factual assessment that's already been done at the domestic level. But in addition, there are specific elements that are inherent to the pushback that make the evidencing also hard. So first of all, states push back people in very informal ways. So they don't issue removal order, that don't go on record, that don't document also like detention practices. So this means that state documents, which are important, are not actually always available or often are not available. In addition to that, and civil society organizations have documented this, states at borders often also actively obstruct the creation of evidence. So they confiscate phones, or they don't allow access to border areas for human rights defenders and journalists. But also when evidence has already been created on phones by pushback survivors, they often confiscate phones and thus destroy the evidence. So these are dynamics at the border, which make it very hard to then really convincingly evidence pushback at the court. In our co-authored article, The Politics of Legal Facts, Grażyna Baranowska and I have argued that this good faith principle, so this principle that judges assume that states have complied with their rights, with their convention obligations, should no longer apply when there is evidence, including in case law, that states have actually not complied with their obligations under the convention, so that then the burden of proof needs to be shifted. So what we're arguing is actually something for greater consistency, and we think that this is important because this is important to have a regional human rights court where the version of facts is independent from the version of facts by state. trying to document pushback incidents for legal purposes. For doing that, it's really important to understand and also respect how registry staff and judges at a court assess evidence. What are their expectations? So our research has shown that judges at the ECTHR tend to weigh state evidence more heavily than non-state evidence, and also that it is really important, or that one strategy can be to shift the burden of proof, because then it becomes the task of the state to evidence that they have, in fact, complied with convention obligations. So the two best practices, or like more strategies that I would propose after having done this work, is first of all trying to shift the burden of proof. So yes, the good faith principle means that normally the burden of proof is with the applicant, but it can be shifted. It can be shifted in specific instances. For example, when it is evidence that states have made wrong statements. One can document wrong statements when there are internal contradictions, but also human rights defenders or civil society actors can also document not just the rights violations and the pushback, but also the documentary practices by states. Another example for trying to shift the burden of proof would be to also document how hard it is to document pushbacks. Because when there is a stark asymmetry between access to information for states and pushback survivors, this can also, by a lawyer, be used to make an argument to shift the burden of proof, and that makes a big difference for a pushback survivor's case. So documenting not just the pushback, but also the difficulty to document the pushback. The other strategy that I've been thinking about after having done this research is, and also collectively, as a scholar, you don't work in isolation, so it's also collectively with lawyers and legal scholars. So the other strategy is to look for ways to oblige and force the state to go on record. If state evidence is what we need, how can civil society actors and lawyers force the state to go on record? And here, at this stage, 3 examples come to my mind. It's possible to make freedom of information requests. We know that there's more and more surveillance at borders. Surveillance material can also actually accidentally include evidence about problematic state practices. Freedom of information requests can get access to this evidence, and then that would be state evidence. Another tool or mechanism that one can use to oblige the state to go on record is interim measures. Interim measures are measures, there are applications to the court. They're not actually, one doesn't have to be a fully trained lawyer to make interim measures. They're relatively short and easy applications. And they're designed to prevent harm. So one asks the court to prevent harm, so to prevent the actual pushback. Now, even if the court doesn't respond fast enough to be able to prevent the pushback, the court, in the course of treating this interim measure, can ask questions to the states that are doing the pushback. And when this is done, when the court asks a question to a state, then the state under the convention system is obliged to respond, and this then also creates state evidence. States are also obliged to answer the questions from courts in full applications. So here, lawyers and civil society actors can collaborate and actually come up with very precise lists of documents that exist and documents that should exist, which can be included in full applications and which, can be suggested to the judges as a starting point to make information requests to states. We cannot expect judges to be experts at what happened at borders. And so there is an avenue, a constructive avenue, where there is a way to force the state to go on record. And so there are ways within the existing system to make pushback facts more visible. And for both strategies, for both obliging the state to go on record and for trying to shift the burden of proof, it is really important to work in teams and to work collaboratively. So even if the conclusion of my work is that it is more interesting to use the law to produce evidence than to produce evidence to change case law, we need the expertise from the social sciences and from law and from practitioners in order to be able to come up with these, to be able to use these tools to actually make these strategies work.